Is what if your end buyer or assignee of an assigned purchase contract fails to perform? So you've put a contract or a property under contract. You're the original buyer and you decide that you're going to wholesale it. You're going to assign it to somebody who's going to be the end buyer. And the end buyer then is struggling to perform, or they're not communicating, or it just doesn't look like, hey, this thing's going to happen with this end buyer. They're not performing. And then you get to the close of escrow date, and all of a sudden that end buyer fails. They don't close. They don't provide the funding. And now you have a contract that's out there, but no end buyer. What does that mean to you as the original buyer and the assigner of the purchase contract? Well, your remedies and what you can do really depend upon the language of the contract itself and then the language of the assignment. Most real estate purchase contracts have a cure period, which means that if the close of escrow date comes and goes, that doesn't mean that the contract is automatically terminated. What that generally means is that the seller must come forward and send out a notice, a written notice to the buyer saying, hey, this close of escrow date came, it went, and you failed to close. You are in breach. And if you don't close within, sometimes it's 3 days, it can be longer. The purchase contract that I prepare for wholesalers has a 10-day cure period. But if you don't close within the 3-day or the 10-day cure period here, then we don't have a contract. It's terminated and I get to keep the earnest money. Well, you as the original buyer want to do something with the contract, right? Because now you're within that cure period. You're thinking, okay, maybe I can close on it. Maybe I can find an end buyer, but maybe let's figure out what the options are. So can the end buyer then say, okay, I'll do something within the cure period? Maybe, maybe not. It depends upon the language then of the assignment. Does the assignment provide an exception to the assignment of rights under the contract for the end buyer's right to receive a cure notice under the contract? What I mean by that is, does the assignment basically tell the end buyer, hey, here's the close of escrow date. If you don't close by this escrow date, the rights under the purchase contract automatically revert to the original buyer, and you have no further rights. You do not have a right to receive a cure notice. See, an assignment generally assigns all rights under a contract to the third party, meaning the full bundle of rights is assigned, which would include the right to receive a cure notice. Most assignments are, a couple of sentences, a one-page document that basically say, I, as the buyer under this contract, assign to you, assignee, all my right, title, and interest in this purchase contract, and you give it all to the assignee / end buyer. And if you do that, the end buyer has a right to basically receive the cure notice and perform, and you have no rights. You're out. You can't do anything. So you need to make sure that the assignment states, I am assigning to you all of my rights except the right to receive a cure notice from the seller, meaning the minute you don't perform by the closing date, you are out, and that the rights under the contract revert back to me as the original buyer. And then at that point, I have the benefit of the cure notice. I can either perform or I can go find another end buyer who can perform, but the original end buyer, the original assignee, has no ability to control that, no ability to be involved. They're out of the picture, and you can move forward to maybe save the transaction. So that's what happens if the end buyer of an assigned purchase contract fails to perform.